Welcome to the Five Stone Buildings webinar program. We have just opened the live link, so we're just going to wait for a few minutes to allow everybody to join before we start. Welcome to the Five Stone Buildings webinar program. We've just opened the live link, so we're just going to wait for a few minutes to allow everybody to join before we start. Good afternoon, everybody, and welcome to the Five Stone Buildings webinar program. We've just opened the live link, so we're just waiting for a few minutes to allow everybody to join before we start. Whilst we are waiting for people to join, I shall just remind you of the house rules. So just to remind you that this webinar is being recorded, and a copy of the recording will be available afterwards on our Five Stone Buildings website. If you have any questions throughout this webinar, please put your questions into the Q&A box on the bottom of your screen, and we will try to come to the questions at the end if we have time. And I will now hand you over to Luke Harris. Thank you.
Well, good morning or good afternoon, everybody. Thank you very much for taking the time to dial in and immerse yourself in the topic of solicitors' equitable liens for the next 30 to 40 minutes or so. By way of explanation, I was thinking at the beginning of this year that I should probably, rather than just stockpiling cases, reading them and waiting for them to turn up at some convenient point in the year or useful point, get on the front foot, pick a topic which I thought looked interesting, and do something constructive to engage with it, take a bit of time to have a look at it. And so this webinar is really the offshoot of that, which is therefore my first and as yet unbroken legal resolution for the year. So I decided to, as I say, pick something and just spend a bit of time thinking about it and developing some thoughts. And no sooner than I'd done that, but I spotted the case of Candey and Crumpler, which is the decision that is trailed in the blurb for this webinar. And Candey and Crumpler was a case which I saw was out just before Christmas, and it concerns the solicitors' equitable lien for their fees. And I thought that looked like the sort of topic that might interest people, or might be of some use or relevance at least. And so that was the one that I decided to alight on. So I'm going to spend a bit of time this morning, as I said, about 30 to 40 minutes, just exploring that decision and also some of the law that surrounds it. So we're looking then at the solicitor's equitable lien, and the equitable lien is, of course, a lien. Surprise, surprise. The lien, as we'll all remember, is one of 4 property interests which are recognised under English law. The others being the mortgage, the charge, the pledge, and then with those 3 you have, as I say, the lien as well. The mortgage is, of course, the conveyance of property as security for an obligation. It's a non-possessory form of security. The charge is another non-possessory form of security. It's an equitable interest, which is the form of a hypothecation of property towards the satisfaction of a debt. Again, non-possessory. The pledge is a possessory form of security which applies in relation to tangible movable property. So the essence of a pledge is that it's created where property is delivered for the purposes of creating a security interest. So that's actually the primary purpose of the delivery. And last of all, you come then to the lien. And the lien is similar to the pledge in that it involves personal property, but it differs from the pledge in that, unlike the pledge, the delivery wasn't for the purposes of actually creating a security. The delivery will have been for the purposes of something else, usually the performance of a service. So, for example, the delivery of a car to a garage, and work being done by the garage owner, and then the garage owner asserts a claim. So essentially the lien is a right of detention, a right to keep hold of property while some obligation is outstanding. And I've put up on the slide there some of the main points about the shape of liens. What I was just describing by way of a right of detention is really covered by the first bullet point on the slide. So you can see that there I'm talking about what are known as possessory or retaining liens over personal property, as I say, rather similar to the pledge. Now, the possessory or the retaining lien arises in a number of different ways, three principal ways. The first of them is as a matter of law, just by operation of the common law. The second is by virtue of statute, which is obviously, again, by operation of law. And the third is consensually, but by virtue of a contract. So those are the three bases upon which possessory or retaining liens over personal property can arise. And you'll see also that I've made the point on the slide there that you can have a general lien or a particular lien. And a general lien is basically the right to hang on to something for so long as there are any sums which are due. A particular lien is the right to hang on to something for so long as there's a specific sum which is outstanding. So that's the possessory lien. There is, however, as you can see, a completely different kind of lien, so-called, which is covered by the second bullet point there, which is the equitable or non-possessory lien. Now, the equitable lien is a very different creature altogether. And I have always thought about these sorts of liens as being really, in very rough terms, an equitable charge which arises by operation of law. So you have some kind of an obligation, and then equity imposes a security interest just because it is fair or conscionable in the circumstances, independent of the intention of the parties, which is intended to secure performance of that obligation. And I think probably to describe it as an equitable charge by operation of law would not be regarded as a particularly controversial way of looking at it. Generally, if you go to the textbooks and you look up what falls within an equitable charge, you'll see that it covers a number of different, an equitable lien, you'll see that it covers a number of different types of rights. You have their vendor and purchaser liens, you have at the bottom solicitors liens, and you have there in the middle the one that I would use most or encounter most commonly, which is the trustee's lien. And that's the lien to secure the trustee's rights as against the fund for reimbursement or recoupment of trust expenses. It's worth noting that there has been some output from the Privy Council recently on in the context of trustees' liens, and it's probably I suspect liens may well become, if you can believe this, the hot topic of the year, because there's been some developments, several developments in that field, particularly, as I say, in relation to trustees' liens. And I think it's probably true that in light certainly of those, it is an oversimplification to think of the equitable lien as an equitable charge. And I'm thinking in particular of the point that the Privy Council has made that the trustees' lien is not really a security interest at all, although it is a property interest. So that would be an example of an equitable lien, which isn't a charge in the sense of a security interest. It's probably, if not difficult, impossible to find a coherent principle to rationalise all of the different sorts of liens which arise. That's a point that Lord Burrows has made in this case that I'm going to look at, called Bott. And needless to say, if Lord Burrows can't find a unifying principle, I don't much fancy my chances. But he was saying there that they're really a collection of different principles. And the point was made again, I heard the point being made rather more humorously recently by Lord Briggs in a lecture which he gave to the Chancery Bar Association annual conference in the middle of January this year, about a day after I had decided to do this talk, and I'd put out a banner for it on LinkedIn. I turned up to the Chancery Bar Association lecture to find Lord Briggs was talking about equitable liens, and I had assumed that he was talking about the trustees' lien. And you can imagine my delight when I found out that he was actually talking about solicitors' liens. So you have the benefit, I think, of some of his distilled wisdom passing vicariously, although hopefully haven't garbled it too badly. Anyway, the point that Lord Briggs was making was to say that the equitable lien is really, as he put it, a rag bag of proprietary interests recognised by equity using a rather inappropriate word borrowed from the common law. And the Chancery Bar Association, being the kind of gathering it is, this roused a chortle from the audience. But it's a serious point. The rights are quite diverse. Now, turning then specifically to the solicitors' lien, what is it that the solicitors get from the law? Well, the first thing they get is the common law retaining lien that I was talking about at the beginning. This is a general lien, so it's the more generous sort, where you can hang on to papers and personal property which has been delivered up to you by the client, pending satisfaction of all sums which are due and owing on the client's accounts. And it's a right to detain those documents, and it's typically or characteristically thought of as being in relation to things like deeds for properties and so on. Interestingly and importantly, the right actually does extend to cover money which is already in a client account if it's been paid for general and not specific purposes. So if the solicitor can show that money was paid and got general funds sloshing around in the client account, then the retaining lien, the common law retaining lien, can be exercised over that sum as well. So the retaining lien is one right, but you might ask yourselves, and you would know better than I, obviously, how far that right is really of continuing use or relevance in a world where so much is done and transacted off paper. The other right that the solicitors enjoy, which is the one that I want to think about specifically today, is the equitable lien over the fruits of litigation. And this is a right which has been comprehensively analysed by the Supreme Court in those three cases which I've put up on the screen there: Gavin Edmondson, Bott, and Candey and Crumpler. Gavin Edmondson was decided in 2018, as you can see. And in Bott, Lord Briggs expressed himself to be extremely surprised to find that the Supreme Court was taxed again with the question of the solicitor's lien, having only just considered it a couple of years before, in circumstances where Gavin Edmondson was actually the first time that the lien had ever visited the High Court. It had never been to the Supreme Court or indeed the House of Lords before it. You can imagine Lord Briggs's absolute astonishment then, I imagine, to find Candey and Crumpler coming before it, which was argued less than 1 full year after the hearing in Bott. And Gavin Edmondson, Bott was argued 1 full year, less a little bit, after Gavin Edmondson, I should say. And Candey and Crumpler was the decision that then came last, and that was a decision about waiver. So Gavin Edmondson and Bott are two decisions about the circumstances in which the lien will arise. Candey and Crumpler is a decision about the circumstances in which the lien will be lost. So what is the equitable principle? What exactly is the lien? What does it give you? The best summary, or rather the shortest, so that I could fit it on the slide perhaps, shortest and best summary, is the one that was provided by Lord Kitchen early on in Candey and Crumpler, the most recent of the three cases. And as you can see in that quotation, which I put up on the slide there, he described the solicitor's equitable lien as a security interest which is enforceable against the proceeds of the litigation up to the amount contractually due to the solicitor in priority to the interest of the successful client or those claiming through them. And it's in the nature of an equitable charge, enforceable in personam against anyone whose conscience is affected by it. So you can see their high authority for the idea that this is really an equitable security interest which arises by operation of law to secure payment to the solicitor of the fees out of the proceeds of litigation. The second passage which I've put up there underlines another point, another important point about the lien, which comes out very, very strongly from all of the three cases that I've mentioned, which is that the reason that the lien is conferred on solicitors is not because, as Lord Briggs said, I think it was in Gavin Edmondson, that it's not because the court has some special fondness for solicitors and wants to help them out, but it's because the lien serves a really important public policy interest, which is one that is more and more important, and that is promoting access to justice. So by providing the solicitors with a lien, the idea is they are comfortable that they're able to, or they will get paid at the end of the day, and it encourages them to take work on the tick, basically, and that is good for access to justice. So looking at the two first decisions, Gavin Edmondson and Bott, I don't want to spend a great deal of time wading through the facts on these. I'd rather pull out some of the key points that they decide. But it is worth just having a quick look at what was going on in both of them, because it's important context. So I'll take each of them very, very briefly. As far as Gavin Edmondson was concerned, Edmondson was a solicitor which was entering into CFAs with clients in relation to low value personal injury claims. And Edmondson had a business model which involved, as I say, entering into these CFAs to act for the clients, and then notifying claims through the RTA, Road Traffic Act portal. I gather that the portal is an online tool which allows solicitors for claimants to notify insurers directly in relation to low value road traffic accidents. And where the insurer doesn't deny liability, but there's a question about quantum, it provides a forum for those questions of quantum to be negotiated or determined cheaply by the court. And importantly, the insurer has to pay fixed costs and charges at various stages as the claim progresses through the portal. And what was happening was that, having been notified of claims, one of the insurers, Haven, had started a practice of contacting Edmondson's clients directly and seeking to settle with them directly. And the effect of that was, of course, that it cut Edmondson out of the fees that it would be entitled to under the portal scheme. Edmondson eventually got fed up with it and sued Haven for the fees and costs which it was being denied. And the Supreme Court held that Edmondson had a lien, had a solicitor's lien, which did protect its contractual right to be paid under the CFAs, that Haven had notice of the lien, and therefore the claim should succeed. So that was the position with Edmondson. The second case, which, as I say, just came along just a few years afterwards, was Bott. And Bott was another case involving a very enterprising solicitor. Bott specialised in handling claims which had been brought by airline passengers who were entitled to compensation under some EU law, fairly modest compensation, where their flights had been cancelled or delayed. And the problem traditionally with these sorts of claims was that they were very expensive to pursue. They were disproportionate to pursue because the client wouldn't want just to employ the services of a solicitor to bring the claim, because it would be much too expensive, bearing in mind the fairly modest value of the compensation that you can get for cancelled or delayed flights. So Bott very enterprisingly developed a system which worked through an online tool, again, this time involving a very high degree of automation, which allowed Bott to process many thousands of claims and to put those claims to the airlines in bulk. So Bott was operating a sort of sell them cheap, stack them high system in relation to these claims. And again, it notified the claims to Ryanair in this particular instance. And Ryanair would traditionally settle the claims by paying Bott Bot would then deduct a relatively modest amount, a very modest amount actually, from the sum that was due to the client, and then it would pass the rest of the money on to the client. Now, in 2015, Ryanair established its own online tool for progressing claims, but many people still wanted to use Bot's services. The following year, in 2016, Ryanair then started paying claims which had been notified by Bot directly to Bot's clients. So again, as in the Gavin Edmondson case, this cut the solicitor out. It required Bot to then pursue the clients for their fees, and Bot found that their recovery in that regard was pretty low. So again, Bot brought a claim on the strength of the solicitor's lien, arguing that Ryanair should compensate it for the money which it had lost. Now, whereas Gavin Edmondson had been a decision that was unanimous in the Supreme Court, in Bot, the Supreme Court split on the question of whether the lien was engaged. The majority, Lords Burroughs and Briggs and Lady Arden, held that the lien was engaged and protected Bot's interests, so the claim ultimately succeeded. But the minority, Lady Rose and Lord Leggett, took a different view. They thought that the trigger for the lien had not actually arisen, so that Bot was not able to take advantage of the equitable right. And I'll come back in a minute just to look at why that was. But just drawing the key points out from these cases, if you read those two cases and you also read Candey and Crumpler, you'll get a very good sense of the important elements of the right, and I've attempted to summarize them on these two slides. The first point is, as you would expect with an equitable right, that it's underpinned by principles of justice and conscience. The idea behind the equitable lien is basically that the solicitor, through hard work and endeavour, has spirited into existence an asset which didn't previously exist. That is the fruits of the litigation. So it could be a judgment debt, it could be a settlement sum, whatever it might be. But that is a sum of money which wouldn't have existed were it not for the efforts of the solicitor. And the justice of the case is that the solicitor should therefore be paid, have first dibs before anybody else, because if it weren't for the solicitor's work, the asset wouldn't exist at all. The second point, which is again a public policy point, and it's the one I've already made, is that the right is justified with regard to access to justice, on access to justice grounds. That's a very, very strong theme of the reasoning, certainly in the first two cases in the trilogy. And it's important to remember that policy consideration when you're trying to work out what the limits of the right are, and what the content of the right is as well. So public policy justification. Third point is that the right must be recovered, the fund must be recovered through the instrumentality of the solicitor. So it has to be, as I said before, the product of what the solicitor has actually done. It can't just arise independently of what the solicitor has done. But Lord Briggs has made the point in one of those cases that it's a very low threshold and very easy to pass. And the work that the solicitor doesn't have to pass any particular requirement of skill. It's not the case that you have to be the only reason that the right comes into existence. The solicitor doesn't have to be the sole cause of the right. And it's not an objection, as Bot shows, that the work that is being done by the solicitor is largely being automated. And that, of course, is going to have implications for things like AI going forward. Now, the lien is being an equitable lien doesn't depend, like the common law retaining lien, on possession of property. It doesn't matter that the fruits of the litigation have never come into the hands of the solicitor. The lien simply operates as a first charge, a first ranking right on the proceeds of the litigation. And because it's a charge, because it's a property right, it binds third parties with notice of it as well. So essentially it's a secured interest, and it's the right to be paid first out of the fund. And that really does mean first. The solicitor is absolutely at the top of the tree. And you can see that from the last point, which is that the right survives insolvency. So if you're working for a client who later becomes insolvent, the solicitor has this first ranking right, not only in relation to fees done after the insolvency, but fees incurred for work done before the insolvency. And it's such a powerful right, it's so prominent, and it sits so high at the top that it even beats the claims of the office holders, like the liquidators or the trustee in bankruptcy, for payment of their expenses as well. Last point on that slide is that it said that there has to be a fund in sight. This is an expression which comes from a case called Refold number 4, as I now know, which made me smile, because Refold is a case which those practicing in contentious probate will know. It's a rather nice claim about knowledge and approval, where Mr. Justice Scarman uses some incredibly lovely Baroque language about darkness and suspicion in relation to wills. That was Refold number 5, but it turns out that Refold number 4 is all about solicitors who wanted to be paid and were worried that they weren't going to be paid. And Mr. Justice Scarman uses this expression that there must be a fund in sight as a threshold for equity to be able to act to protect the solicitor. Now, one thing which is clear about the right is that it does not extend to cover transactional work. So fees which are incurred on transactional work are not protected by the lien, which only bites on the fruits of litigation. But that raises an obvious question as to how you define litigation. What is litigation for these purposes? And this was where the Supreme Court split in Bott. The minority judges, Lady Rose and Lord Leggett, proposed that the trigger for the intervention of equity should be that there was an actual or reasonably anticipated dispute. They said that there had to be an actual or reasonably anticipated dispute before the work which was being done by the solicitor was capable of being protected by the lien. Now, that's all very well and good, but it does then beg the question on the facts. Well, why was it that in Gavin Edmondson, there was, even on the minority's view, a claim to the lien, but on Bott, which was superficially quite similar, there wasn't a claim. And actually the best explanation of why it was that applying the minority's proposed test, Bott would have failed, was actually found not in one of the minority judgments, but I think it was in Lord Burroughs's judgment at paragraph 89, where he was summarising what they were saying. And in that quotation that I've put in the middle of the slide there, what he was basically saying was that the test, so the minority would have applied it, or the test that as the minority would have applied it, would have caught claims as in Gavin Edmondson, but not in Bott, because in personal injury cases, you can reasonably anticipate that there's going to be a fight about something, whether it's either liability or quantum, you can reasonably anticipate that there's going to be some form of a dispute. However, from the minority's perspective, if you're dealing with a claim under the EU legislation for delayed or cancelled flights, it really is usually absolutely blindingly obvious whether or not there's a defence or not. And there normally is no defence. It's very, very exceptional. And that would appear to be why the minority thought that applying their own test, the claimants in Bott would have failed, but Gavin Edmondson was decided as it was. The majority, however, in Bott didn't disagree with the application of that test. They rejected the proposed test altogether. For the majority, Gavin Edmondson had decided that the trigger for the intervention of equity was at a different threshold. And the formulation that they all settled on was the one that you see in Lord Burroughs' judgment at paragraph 88. So Lord Burroughs formulated it as being that the lien would apply in relation to the making of a client's claim with or without proceedings, which significantly contributes to the successful recovery of a fund by the client. So for the majority in the Supreme Court, it wasn't a question of actual or reasonably anticipated dispute. It was simply that there had to be a claim. The solicitor was putting forward a claim with or without proceedings, and provided that they had significantly contributed to the successful recovery of a fund, that was sufficient for the lien to bite. And for the majority, BOT's activities, although very automated, nevertheless satisfied that threshold and triggered the right of lien. Now, at this point, I'm just going to break off from equity and delve for a moment into statute, because while equity was busy hammering out the equitable lien, Parliament was also beavering away. And the background to that was that in Shaw and Neal, the House of Lords had decided that the lien did not apply in relation to real property, which the solicitor was instrumental in recovering. And that was thought to be a lacuna in the law. So Parliament intervened and passed some legislation in 1860, which is now contained in Section 73 of the Solicitors Act 1973. And as you can see, I've put it up on the screen there, that gives the court jurisdiction in circumstances where a solicitor has been employed to prosecute or defend some proceedings. And I would emphasize the word defend, because you will notice that usually, or certainly the cases that I'm talking about, it's a situation, we're talking about a situation where the solicitor acting for the claimant has spirited, as I say, a fund into existence. But this right here applies in relation to defence as well. The court is empowered to declare, note declare not grant, a charge over the property recovered or preserved through the instrumentality of the solicitor. And the statute makes clear that it's a right which will prevail, except as against bona fide purchasers. Now, what's the interaction between the statutory charge, which looks quite similar to the equitable charge? Well, this was considered, this is touched on in some of the cases, but I picked out this extract from Lord Kitchen in paragraph 42, who makes the point really that the statutory charge under section 73 is not really giving the solicitor any different right. It's really providing a mechanism to better enforce the right which the solicitor has in equity. It allows the solicitor more cheaply and speedily to enforce a right that he or she already possesses. And Lord Kitchen goes on to make the point as well that if you waive one right, you'll probably be waiving the other. So you could think of the statutory right as perhaps being in the nature of a procedural right, although it has to be said that it does have some substantive content, because whereas the equitable right won't bind land, as I say, the statutory right will bind land. Anyway, coming back to the equitable right, because it's an equitable property interest, unsurprisingly, it can bind third parties whose consciences are affected. And what that means was considered in this case called Cairns Solicitors. It's a Court of Appeal decision from a few years ago, which was approved by the Supreme Court in, I think it was Bott, one or other of the cases anyway, Bott or Edmondson. And the Court of Appeal considered that if the solicitor either colludes with the client or has notice of the other party's solicitor's claim, then the conscience of the third party is affected. So those are alternative conditions. Collusion is talking obviously about the situation where the third party, the defendant, decides to get together with the client of the solicitor, pay the money direct so as to cheat the solicitor out of the lien. Notice is separate. It's simply that if the third party defendant has notice of the claim, then they will be potentially bound by it. And as that quote says, the remedy which you'll get is ordinarily going to be preventative. And one thinks there about an injunction. So you might be able to go off and get an injunction to prevent the defendant from, for example, paying the proceeds of a settlement over to the client. But in an appropriate case, it can take the form of a dual payment. So the third party who pays the client with notice of the solicitor's right may find, as in both Bott and Edmondson, that they're facing a claim for payment again. And that's not really surprising if you think about it, because it's an in personam protection of a proprietary interest in equity. So if you think about a situation with a trustee in a fund, trustee acts in breach of trust, the first place that you're going to go is to think about whether there are proprietary remedies that you can assert to recover the fund. But if you can't recover the fund, if there are no proprietary remedies, then of course you've got an in personam right for breach of trust against the solicitor, or knowing receipt against some third party perhaps. And this is really the equivalent. This is the personal dimension to the liability that the fund holder has if they pay away the fund knowing of the solicitor's equitable interest in it. Last point just to make on the actual right itself, and that's to talk about discretion. Because this is an equitable jurisdiction, strictly speaking, it is open to the court to decline to allow the solicitor to have the right. The court can deny the solicitor the right on discretionary grounds. But as Lord Briggs said in Bott, it's really going to be a rare case where the solicitor is denied the right, because the lien takes the form of a property right, as I keep saying, and it would be a very strong thing for the court to turn around and deny the solicitor a prima facie property right on a discretionary basis. So you can assume, I think, that if the ingredients of the right are there, if the trigger for the right is there, as considered, as discussed and analysed in Edmondson and Bott, then all things being equal, you'll be able to take advantage of it, and it will be a rare situation that the court will deny it, although it would retain to itself the discretion to do it if, for example, there was a case of seriously unclean hands on the part of the solicitor or something of that nature. Right, having said all of that, I alight on the case which I have snared you in by reference to, which is Candey and Crumpler. Now, Candey and Crumpler was a case all about the circumstances in which the lien can be lost. What had happened in Candey was that the firm of solicitors Candey had acted for a company in relation to worldwide litigation, including some heavy litigation in London. And they were acting from April 14 to March 16. And during the course of that period, certain things happened. In March 2015, the company began to get into serious financial difficulty and sought to negotiate or renegotiate its retainer with Candey. And by October 2015, Candey and the company had entered into effectively a replacement fee structure, which had two components. The first was that there was a fixed fee agreement, which provided for a lump sum that was due to Candey in certain circumstances, and those included if the company became insolvent. And the second element was that there was a deed of charge, which was expressed to be a fixed and a floating charge over all of the company's assets. The company, importantly, took legal advice about the agreement before it entered into it. So that's 2015. February 2016, just before Candey's retainer was terminated, the company goes into liquidation and liquidators are appointed, and this triggered Candey's right to be paid the fixed fee under the agreement. So what Candey did is it put in a proof of debt, and it referred to the charge, it referred to its security under the charge in support of the fixed fee, but it made no reference to the to any pre-existing equitable lien. So that was the proof of debt. And just a couple of weeks after that, the liquidators, who had managed to negotiate without Candey's help, managed to settle the London proceedings with the defendant on terms under which they were to receive stonking great sums of money, and Candey were disinstructed. Now, the procedural background to the decision in the Supreme Court is quite complicated, and there were lots of sort of lower proceedings going on. But in the course of those proceedings, some of those proceedings, a couple of things were determined. And the first thing that was determined was that the deed of charge that Candey had entered into wasn't, as it purported to be, a fixed charge, but it was I've put fixed there, it should be floating. It was a floating charge only. So that's wrong on the slide. It was a floating charge only. And the other thing which the courts established was that because the company was unable to pay its debts at the time it entered into the charge, under the Insolvency Act, the charge was only a valid security for fees which were which post-dated it. So this was not really much help to Candey, and I think there was, maybe still is, a question about the quantum merit as regards the fees which Candey was providing after the charge was entered into. But obviously Candey wanted security for the whole of the sum which it said was due to it. So Candey then asserted that it had an equitable lien as well as the charge. And in further proceedings, and these were the proceedings which eventually snaked their way up to the Supreme Court, Candey applied for the equitable charge to be converted under the statutory provision that I've just mentioned into a charge granted by or declared by the court. The deputy judge, however, who heard the application, held that Candey had waived the lien when it accepted the deed of charge. The Court of Appeal agreed. The Court of Appeal said that Candey must have been taken to waive the lien, because there were terms in the charge which were inconsistent with the lien, and it flagged up these 3 points on the bottom of the slide in particular. First of all, the charge covered assets which would otherwise be covered by the lien. Second, the charge, unlike the lien, conferred a priority on a third party. So as I said before, the lien would have given the solicitors, Candey, absolute first dibs on the fund, even in priority to the liquidators. Under the charge, Candey had agreed that their security would come after that of another party, which was a litigation funder. So in that respect, the priorities were different. And then last of all, the Court of Appeal pointed to the fact that the fixed fee agreement provided for an interest rate of 8%, which would not have been payable under the lien. In the Supreme Court, the court considered the various principles, as you would expect, for actually deciding whether or not there had been a waiver. So we have a good and thorough, comprehensive statement of the relevant principles. In a nutshell, it boils down to the intention of the parties objectively ascertained, and that intention may be expressed or inferred. So the question is whether, in all of the circumstances, the parties objectively intended, to waive the equitable lien. And as you can see from that quotation at the bottom from Lord Kitchen, in deciding whether there's been a waiver, you look at everything. You can't list out all of the factors that might potentially be relevant in any given case, but what you do note is that there are various recurring themes, and one of them is that the courts will look at the new security or a new security which has been taken by the solicitor and look at the extent to which it's consistent or inconsistent with the equitable rights. And the other theme, or another theme which comes out, is whether or not the solicitors have actually explained to the client that they were reserving their earlier rights. In subsequent passages in the judgment, Lord Kitchen then develops these or comments on these various factors, and I've set them up on the screen there, but you can see that there are various different factors in relation to new security which are likely or may well point to a waiver of the equitable lien. So where the new security is over different property, that can point to a waiver. Where the new security carries with it a right to interest, can point to a waiver. Likewise, where the security covers assets which were covered by the original lien. If you've already got a lien, if you take another security on top, it gives rise to an inference perhaps that you've waived the lien. And again, a new security which has different priorities from the ones which would operate under the lien. Another point though which Lord Kitchen made, which I think is really very important, is to emphasize that it is the duty of solicitors to give express notice to clients if they want to retain the lien. And if they don't give express notice to the clients that they want to retain the lien, then it readily gives rise to an inference that the lien has been waived. Ultimately, when it applied these principles, the Supreme Court held, in common with the courts below, that Candey had indeed waived the lien. And it picked out these 3 points. First up, it created a consensual security over the settlement proceeds, and that was inconsistent, the Supreme Court thought, with the continued existence of the non-consensual security which arose under the lien over the same property. The second point was the point that the Court of Appeal again had picked up, which was the ranking of the priorities. So those were the 2 key points. And then the court went on to say, well, furthermore, on true construction of the fixed fee agreement, which you have to look at with the charge because it creates a new package of rights, there had been no reservation of the equitable lien. So on true construction of the agreement, no reservation. The agreement was clearly intended, as it said in terms, to supersede and replace any pre-existing fee agreement. Now, the last point on the slide there, I think, is really important to note. And that is, just going back, if you see that to that slide, the last slide there, the last bullet there, the duty that I emphasised on the part of solicitors to emphasise or to explain if they want to keep the pre-existing lien. Well, this point here ties in with it, because what Lord Kitchen said is the fact that they had been off to take independent legal advice did not help Candey. A solicitor is not absolved of that obligation, that's the obligation to explain, simply because the client has agreed to take independent legal advice in relation to the new security. And that's because the independent advisor is not in a better position than the client to discern the solicitor's intention. So, really important point to note, practically, it's no good sending the client off to see somebody else with a draft agreement saying, get some advice on this. That won't be good enough. If you want to retain the lien, it would appear that what you've got to do is actually say so in express terms. And if you don't say so in express terms, then you are, there's a very strong possibility that you will be found to have inadvertently waived the equitable lien. I've put a slide in at the end called takeaway, because everybody these days puts slides in at the end called takeaway. So I've tried to think of a takeaway. And the one that I've come up with is actually to go back to this mirthful talk that Lord Briggs gave to the Chancery Bar Association a couple of weeks ago. It was a brilliant talk and covered a lot of ground, which I've certainly not had time to cover today. But one of the really big points that he ended with, I think, which ties to the point that I've just made, is that ultimately the equitable lien is a right which the courts are very generous in conferring on solicitors. It's very, particularly after Edmondson as interpreted by Bott, it's a very easy right in terms of the circumstances of its arising. It quickly comes into being. And that's done, as I said, for reasons of public policy. But as Lord Briggs says in this passage here, the moral of the story may be that the court will readily give the solicitor a very valuable security for his fees in the form of a lien over the fruits of the litigation. But if solicitors want to go one better, they do so at their own peril and will receive no sympathy from the court if they do not seek to preserve their lien in the clearest express terms. So there you have it from Lord Briggs himself. It couldn't be clearer. You must say it if you want to keep the lien and put in place some enhanced or different security for your fees. So that, I hope, is a very clear takeaway. I have gone horribly over what I said I would do, so I'm sorry about that. I think in the circumstances, although Joe did say at the beginning that we would take questions, I probably won't take questions now, but I'm very keen to hear if anybody has any questions or thoughts or comments, then do please give me a bell or drop me an email. I'll happily respond. I've, for my sins, promised Richard Dew that I will now write up something on this, which is a pretty tall order, having just heard Lord Briggs's or seen Lord Briggs's summary of it. So all thoughts on this topic gratefully received, as I hack-like try and pen something of use for whichever publication Richard was acting on behalf of. So there we have it, solicitors' liens. I hope it's been of some use, and as I say, do get in touch if you're interested in any questions or comments. Well, with that, I'll say goodbye. So thanks very much. Have a nice weekend. It's only about, 4 hours, so everyone can limp through, and hope you have a good weekend. All right, see you later then. Thank you very much. Bye-bye.
Thank you, everybody, for joining us. Before you all go, I'd just like to remind you that we have started our first in-person seminars. The first in-person seminar will be taking place in March, so please do go ahead across to our website and look at the events tab to find out what that's all about. But thank you for joining us. Goodbye.